The next question we have is by Yazan. Um, she, okay, so I submitted an idea to a global car company and they rejected it due to the lack of a patent. After a period of time, they implemented it on their cars. In this case, do I have the right to sue them knowing that I have the correspondence?
Mm, yeah, so this is interesting because I'm thinking this is maybe patents, right? Or maybe the idea is the name of a feature and they said, well, you don't have the registration, so we can't do it. And then they went ahead and used it anyway. But let's say it's a patent, right? That you had a feature, an actual invention that you felt like could be used on their cars. They said you don't have a patent, we can't use it, and then they went and used it anyway. Most most countries, patents are first to file. It's not like trademarks in the U.S. Trademarks in the U.S. for the most part, first used in commerce is what determines who has prior rights. That's not always the case. There's always exceptions when it comes to the law. But patents universally, almost universally, first to file is who gets the protection. Now, there are other things that could be in play here. Is it a patent or is it a trade secret? Right? It could be something different than a patent. Um, if it is a patent, and you don't have any protection, could you get protection? Could you file? In some instances, you could introduce the patent to the public and then the clock starts ticking for when you file, right? But you've got to move fast. I see very often where people will have an opportunity to gain patent protection after they've introduced the idea to others and they don't move fast enough to get that protection. And so even though they had that great fix for their problem readily available, by not moving fast enough, they didn't get the protection, right? So in some cases you can, even after you introduce it to the public or you introduce it to others, you can still go ahead and move forward with protection. Patents, you really have to be thinking about geographically where you're located. This is known as jurisdictions. You've got to think about geographically where you're located because you can have patent protection in one country but not another. We've got clients where they're based in the United States. We start their patent protection here and then we manage their portfolio of patents in the countries where they plan to sell whatever product or good incorporates the patent, right? So maybe they're selling that product in 5 regions and 2 countries, right? We've got to make sure that they've got patent protection in those 5 regions and 2 countries, not just in the United States. It could be that they're in a country outside of the United States and the company is outside the United States and they want to start selling in the United States, or they already started selling in the United States. In some instances, you can, whether it's into or outside of the United States, you can use your patent protections in other countries, sort of piggyback off of it to get a registration here or to pursue a registration here. Another way you can, there's a lot of tactics depending upon what your goal is. So that's one thing to keep in mind. What is your goal? What is the goal that you want? Do you want recognition? Do you want money? Do you want a long-term royalty stream, which is what a lot of inventors want? They don't actually want to produce. They just want to receive a royalty income from their invention, right? What is it that you want? If you don't have an idea of what you want, it's very hard to come up with a strategy, a legal strategy that gets you there. People can easily start throwing out ideas like sue for patent infringement, invalidate the patent, put them on blast, publicly shame them. But All of these are just ideas. What is the point of them? What is it that you would like to have? And what does that do for you that you can't do now, right? So some businesses are really just about protecting the inventions that people come up with. That's the business, IP holding, right? Um, you've got to decide what is the outcome that you want and why do you want it? What is it going to do for you? And then the strategy will line up with that. There's a reason why we call our firm Horton Legal Strategies, because so often business lawyers will just start proposing ideas and they don't even know what the client wants to come of it. They don't even know why they want help. You've got to know the North Star to really chart the best course to getting there. Otherwise, you're just throwing out ideas, throwing out legal theories. And then the lawyer becomes the big brain that becomes the center of the room and the most important thing, as opposed to the goals of the client becoming the most important thing. We can't make your goals the most important thing in your representation if we don't know them. So we've got to know that too. Yeah, to give a good response, but that should get you started.